Welcome to the Scaringi Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. There's been a lot of discussion recently about Marsys Law. Marsys Law is a proposed amendment to the Pennsylvania Constitution. It would, for the first time, establish certain constitutional rights for crime victims. Having passed the General Assembly in 2 consecutive sessions, the proposed constitutional amendment is now on the ballot this November 5th. However, the Pennsylvania Commonwealth Court just issued an emergency injunction preventing the tabulation and certification of votes on Marsys Law. So the proposed amendment will still be on the ballot. It's too late to take it off, but its votes either for or against it will not be counted until the underlying litigation that has been brought challenging the constitutionality of Marsys Law is resolved. If the underlying suit is dismissed, then the votes will be counted and certified, and the amendment may pass and become the law of the land. Judge Ellen Keisler of the Commonwealth Court said she granted the injunction because the amendment would have immediate, profound, and in some cases irreversible consequences for the rights of accused people and the criminal justice system. She's right. Many Pennsylvanians, like me, who defend the ancient constitutional rights of the accused, are concerned that this amendment will harm those rights while elevating the rights of crime victims to constitutional status. I should point out that crime victims already have statutory rights under Pennsylvania's Crime Victim Bill of Rights. I suggest that if changes need to be made, then those changes should be made by amending the existing statute, not by amending the Constitution. Amending the statutory rights for victims through the legislative process gives all stakeholders the right and opportunity to be involved, have hearings, examine witnesses and the evidence. It allows the members of the Pennsylvania General Assembly and the people of Pennsylvania to hear the pros and cons of the requested changes before they vote for or against them. Subsequent changes can then be made by simple majority vote. This is not so with the constitutional amendment. It's much more difficult to amend the Constitution than it is to amend a statute. So because Marsys Law is a proposed constitutional amendment, its newly created constitutional rights may be locked in forever without the practical ability to change them in the future. Also, the language of Marsys Law there are several problems with Marsys Law. One is the language of Marsys Law is too vague. For example, it states, "Shall the Pennsylvania Constitution be amended to grant certain rights to crime victims, including the right to be treated with fairness, respect, and dignity, and the right to reasonable protection from the accused," among many other rights. But what does that mean? Fairness, respect, and dignity? Reasonable protection from the accused? What do those new constitutional rights mean? What does dignity mean? What does respect mean? Laws must be precise and clearly understood. That is critically important if we are to remain a state in a nation in which we have the rule of law. If the law cannot be understood or is capable of multiple meanings, like the words respect and dignity and reasonable protection, then we don't have the rule of law, we have the rule of judges, because it's judges who will interpret those words, and judges will interpret them differently. So we'll have different rights for different victims, different rights that implicate different individuals who are accused based upon the judge's interpretation of those very vague words. Also, Marsys Law may compromise the rights of the accused. For example, it gives crime victims the constitutional right to timely notice and opportunity to take part in public proceedings. So now the victim will have the right to be heard in nearly any criminal proceeding. So it would follow then that a victim would have the right to request a continuance or rescheduling of those hearings so that the victim may be heard. This may infringe upon the accused's constitutional right to speedy trial. It would also give victims the right to refuse discovery requests made by the accused. This could inhibit the accused's right to confront witnesses against him, present his best defense, especially if the victim is the only witness, or even preclude access to exculpatory meaning other exonerating evidence that a victim may hold. This new right also seems to contradict Article 9 of the PA Constitution, which states, in all criminal prosecutions, the accused has a right to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor. And remember, in a criminal case, the prosecutor, that is the government, does not represent the accused. It represents the people of the Commonwealth of Pennsylvania. The purpose of the penal laws is not to exact vengeance or retribution. It is to punish those who violate the rules of civil society. Penal laws protect the dignity of the Commonwealth of Pennsylvania. Furthermore, taking a step back for a moment, the purpose of constitutional rights is to protect the individual from the power of the state, not to empower one individual over another individual. That's why the Pennsylvania and U.S. constitutions provide many protections to the accused, including the right to speedy trial, the right to confront witnesses, the right to bail, the right to due process, the right to counsel, the right to remain silent, among others. The constitutional rights of the accused apply because the state is attempting to deprive the accused, not the victim, of life, liberty, or property. Constitutional rights serve as essential checks against government abuse, preventing the government from arresting and imprisoning anyone for any reason at any time. Victims' rights are not rights against the state. Instead, victims' rights are rights against another individual, the accused, who, by the way, has the presumption of innocence. The Marsys Law formula includes the rights to restitution, the right to reasonable protection, and to refuse discovery requests, all of which are personal rights of the victim enforced by the government against the accused, who, by the way, should have the presumption of innocence. Such rights do nothing to check the power of the government, and as such, they should not be enshrined in the Pennsylvania Constitution. There are many other flaws with Marsys Law, which we do not have time to get into today, but I will leave you with one thought. In America, we have the presumption of innocence. That is a bedrock constitutional right that goes back hundreds of years, even before our founding. Marsys Law gives crime victims constitutional rights against the accused, thus infringing upon this ancient right to the presumption of innocence. This is an ancient right that set America apart from most of the world. Let's keep it that way. Vote no next Tuesday on Marsys Law. Well, that's about all the time we have today for the Scaringi Law Lunch Break. I hope you learned a little bit about Marsys Law and constitutional law. If you have any questions or concerns, would like to talk to one of our criminal defense or constitutional lawyers, feel free to give us a call at 717-657-7770 or check us out on the website, on the internet, on our website, scaringilaw.com. Thanks for listening and enjoy your lunch.